Hey everyone, I wanted to address this new memo that USCIS put out regarding adjustment of status. It's a lot going on, and I wanted to tell you what the memo says, who it applies to, and also what you should do. If you are, thinking about applying for adjustment of status, or you're in the process. Okay, so the Immigration Service announced on May 22nd a new policy regarding adjustment of status. And basically, they are departing from existing practice quite significantly. So prior to this memo, we used to file adjustment of status applications for really almost anyone who qualified, and they did not have to depart the US to obtain that benefit, and that was huge. And mostly this was for immediate relative, like US citizens applying for a spouse or a parent or a child. They didn't have to leave the US to get their green card. But now with this new policy, the Immigration Service's new position is that when it receives an adjustment of status application, which is another way of saying the Form I-485 application, the immigration officer has to exercise discretion and determine whether, looking at all of the circumstances, whether that green card applicant should receive a favorable exercise of discretion. Yeah, that's basically what it says. So a favorable exercise of discretion as to whether they should be able to apply and receive their green card in the US. Otherwise, the applicant has to go to a consular post overseas, abroad. To whom does this memo apply? And it very clearly applies to single intent visa statuses. So I've addressed this previously in other videos, like what is a single intent visa, but in short, it's basically a visa that does not allow you to apply for permanent residence or a green card while you're in the US. I mean, the very typical single intent visas are student visas, visitor visas. Those are definitely included in this memo as having to go. If you're on one of those visas, you have to go overseas to get your green card. Those are the single intent visas. And then there are the dual intent visas, which is very commonly the H-1B visa. So the H-1B visa allows you to be in the US and apply for a green card at the same time. And although the memo does address that the H-1B visa is a dual intent visa, they still say that that's not enough on its own to warrant a favorable exercise of discretion. So, it is this policy, it does overreach. It really shouldn't impact people who are here on a dual intent visa like the H-1B. But the way it's written right now, this policy memo, it does indicate that even people on H1 on the H1B visa have to show evidence, or they have to prove by the totality of the circumstances that they warrant applying for their adjustment of status in the US. Okay, so that's kind of the nutshell. I mean, obviously there's more to it. So if you're applying for adjustment of status, you're in the US, and there's now this new policy, how do you show that you warrant a favorable exercise of discretion? So here are a few ways you can do that. So positive factors that will show that you merit, a favorable exercise of discretion are things like family ties in the US, good moral character, national interest considerations. So if, your presence in the US will provide an economic benefit to the US, then that's a positive factor. You can also show, long-term presence in the US and in community involvement. And you can prove that by your tax history, employment history. Good moral character basically means no criminal history, no violations, severe violations against the law. And, you can show national interest benefits by showing, that your specialized skills or your economic benefits of your job, your role, your achievements will help the national interest, and you can probably prove that by employer letters. So the one thing that you should keep in mind is that the policy memo does say that even if you do not have any negative factors, you may still not warrant a favorable exercise of discretion. So it really overreaches and is kind of shocking. Moving on, because this is actually very fluid, the situation, and whether this policy will remain in place. If you are considering filing the green card, definitely contact our office, whether you're filing for a family member, whether you're filing based on your occupation, or based on your skills. Definitely contact us and we can advise you, and it also let you know where this policy is currently. And this leads me to my last point, which is there are various organizations filing lawsuits against the USCIS, stating that this policy is unlawful. So sometimes when this litigation gets filed, that there will be the policy will be placed on hold. We saw this last time, when like the last administration, when there were all these policies coming out that really made no sense and had no legal basis, there would be these lawsuits, and then that policy would be put on hold. So that's something to keep in mind. So depending on where this policy is at the time you file, it's important to know whether you need to prove, a totality of the circumstances that you meet, that you warrant a favorable exercise of discretion. But like I said, there are several lawsuits already about to be filed, and could very easily be overturned. Contact our office. We are staying up to date on this policy, and we will definitely love to talk to you and guide you on the appropriate course of action.